Good evening. Greetings from Lisbon. I'm António Barroso Rodrigues, and I'm an assistant lecturer at the University of Lisbon Faculty of Law, currently developing my research in private law in Portugal. It's my pleasure to be a part of this project and to have my modest contribution be heard on today's topic, which relates to the effects of climate change on private law. First and foremost, I would like to thank Professor Vasco Pereira da Silva for the opportunity he has granted me to talk about this pressing issue. I was invited to talk about the effects of climate change on private law. And so the sole purpose of this video is to give a brief analysis of this problem from the Portuguese legal standpoint. My contribution must be limited to a single point, and that is the liability question that can arise from the climate change problem. Of course, there are several manifestations of climate change impact on civil law, and I'm thinking first of the problem of contract law, and that relates to the concepts of risk, foreseeability, and vulnerability regarding climate change. It relates to all of these problems, but the question still remains, can a risk be considered as such if it is foreseeable by both of the involved parties? So let's talk about the liability question. So since the onslaught of the climate change effects, the common opinion is that climate change represents and grants rights to prevent or demand compensation for environmental harm. There have been several proposals to extend the current liability standards to include new possibilities. As an example, a new tort of duty has been proposed in the United States. It includes an obligation of reasonable notice of service interruption, avoidance of unnecessary power outages, and updating technological available standards in operations and planning to encompass the foreseeable risks of climate change. A distinction must be made between what is shaping and what is enforcing the law, and work, of course, needs to be done on both accounts, but we shall focus on enforcing the law. Climate change related issues are increasingly arising in areas of company and financial law, particularly related to climate change risk and disclosure. Companies now face shareholders that pressure to disclosure climate change related risks to their business. Another hot topic and hot breach for claims is consumer protection law. So several cases in the past decade have related to misleading green advertising claims, such as carbon neutrality or offsetting of emissions, such as the Volkswagen emission scandal known as Dieselgate. There are other key drivers, such as, first, challenging governments and regulators if the national or international commitments aren't met. Second, challenging the current climate change policies or their application. And third, requesting compensation for the costs of the adaptation to climate change. And this last one should not be confused with the first and the most pressing one. That is claiming damages for the climate change effects by individuals. The general opinion is that these climate change effects constitute actionable damages, but there are conditions that must be met. And the grounds for the liability remain the same. Across all countries, the major problem for this liability is the causation problem. And there has been a major wave or refusal to compensate damages because the plaintiff cannot prove the link between the climate change and the damage he has suffered. Of course, that climate change is not attributed to the human species as a whole, but rather to the operation of a specific economic system promoted by, as Cine professor would put it, a global minority. For some, so, the economic model is the one to blame. Nonetheless, we can and should point our fingers to some markets, key market operators. Let's talk about a little more about this issue in the US and the problem of causation. So, in the US, broadly speaking, tort claims may be brought on grounds such as public and private nuisance, negligence, failure to warn, trespass, and unjust enrichment. On one particular case, the plaintiffs claim that the discharge of carbon dioxide and other greenhouse gases caused unreasonable interference with public rights to air and water. This was an issue in the Californian case of the native village of Kivalina and ExxonMobil, a famous energy company. So, a group of people from Kivalina, an Alaskan island, claimed damages from this company for the erosion and weather events they faced, claiming that the weather patterns were caused by the defendants' actions. The case was rapidly dismissed, in part because the plaintiff could not make out the case on causation. Demonstrating a link between the loss incurred and the defendant's actions is a nebulous pattern and process which demands more from the science of attribution that could be at the time provided. In another example, lawsuits brought by the cities themselves of Oakland, San Francisco, and New York against fossil fuel companies have also been dismissed. The courts have found that the basis of the responsibility for addressing climate change impacts falls on the US Congress and the executive branch alone. The issue can be put on the simple terms. Can the causation of an individual be diluted in the whole? The private law dogmatic has faced this issue numerous times. To this extent, we need to operate to assess liability of one individual, the operative cause. The difficulty is determining the quality of this cause. In this context, that is reduced to a matter of proof, whose criteria does not allow for a basis in the civil sphere to create and to demand damages. If we absolutely ignore the real author of the cause of damages, but we know that it must be a person or another, according to the Portuguese law, there is no ground to claim damages. The German solution and the French is a different one. In the German civil codes and the French jurisprudence practices has been the agreement that one can derive and claim damages even if we can't know for certain who is the real author of the damages. The most recent understanding of the European law, and I'm talking about the principles of the European tort law, also go in this effect. They admit that we can hold all agents responsible and explore the level of the relevance of the cause of justification, but first we can claim damages that have been produced by a set of agents, even though we don't know for certain who did it. So the question becomes who's responsible and how. And so answering the first question, the who, the biggest issue that we're now facing is that all the civil claims are a first generation of claims. We have not yet fine-tuned this part. A recent study from the London School of Economics revealed that the number of climate change cases filed globally has significantly increased. More than 1,000 cases have been filed since 2015, the year of the Paris Agreement, covering more than 25 countries. Governments are the most common defendants, but the base of this, these are civil claims, nonetheless, is still the private law. So who can answer for the damages? The states and the companies, but also individuals. Let's focus on the first two. The United States guiding principles on business and human rights provide that states have an obligation to protect human rights from harm by businesses while businesses also have an individual responsibility to respect human rights. So there's a basis. Let's talk about, in further depth, the basis of this claim. As the European Association of Private International Law explained in broad terms, if the claim questions the quality or the adequacy of a state's legislation or evokes the responsibility of said state in relation to an alleged violation of its obligations or duties of care, there is no real issue of applicable law. It will always be the law of the defendant states eventually read in the light of pertinent international norms. There is no problem of international law. And companies face no such problems and can have a claim brought against them for their actions. In 2021, there was a landmark case of Milieu Defensive versus the Royal Dutch Shell Company that sent a striking signal that some courts may agree with legal activists that private companies in particular have a case to answer when they are considered high pollution emitters. Let's talk about the how. The how has been always class actions, and class actions suits against climate change and for the breach of international treaties regarding climate change. Let's talk about that other case, the Milieu Defensive. This was decided by the Hague District Court in May 2021. It was a class action brought in 2019 by Milieu Defensive and other 6 non-governmental organizations and over 70,000 Dutch citizens. The case simply raised the question as to whether a private company can violate a duty of care and human rights obligations by failing to take adequate action to curb greenhouse gas emissions. The plaintiffs argued that the Royal Dutch Shell had an obligation based on an unwritten standard of care that was established and is in the Dutch Civil Code to prevent dangerous climate change. The action was based on the legal principles such as the no harm principle and the polluter pays principle. Those arguing in favor of legal recognition of emissions reduction obligations on the part of companies emphasize that is entirely consistent with principles of equity and fairness for such companies to bear the costs of emission reductions, given that many have benefited extensively from past high emitting activities. Most importantly, the Rome II regulation was deemed applicable to the case at hand, which relates to the law applicable to non-contractual obligations. It's impressive to note that the Shell company based its defense on causality arguments and said on the contribution that the contribution of other parties to the emissions, including the one to whom the assets will be sold in response to a court-imposed order, should also be found responsible. And the Hague District Court stated in response that, and I'm quoting, the non-disputing responsibility of other parties does not absolve Royal Dutch Shell of its individual responsibility regarding the significant emissions over which it has control and influence. Each company must independently work towards the goal of net zero emissions by 2050. So, the private international law has not been relevant in this matter, and we can certainly understand why. There have been several cases brought before the European Court of Human Rights, the Inter-American Commission on Human Rights, the UN Committee on the Rights of the Child, with a possible debut before the International Court of Justice. The problem lies with the international courts, particularly outside the European Union. A civil claim brought against a state in relation to its sovereign environmental policy choices will not give rise to issues of royal jurisdiction if the court is a national one. A claim brought to the current international courts can, and so this issue remains an internal national one. Let's talk about the responsibility, the liability of the companies. In Smith versus Fonterra, a different approach has been taken by the New Zealand Court of Appeal, indicated that individual corporate liability for climate impacts is not to be appreciated as the ones that regards to the government. The New Zealand Court of Appeal dismissed the Mr. Smith claims. In assessing whether common law tort presented a suitable vehicle for addressing climate change, the court noted significant conceptual and institutional problems with establishing a duty in tort, particularly because, and I'm quoting, every person in New Zealand is both responsible for causing the relevant harm and the victim of that harm. In the UK, there have been increasing number of claims being brought against parent companies who are said to be responsible for harm occurring outside the UK, albeit those parent companies are not alleged to have directly contributed to the harm costs. Two recent cases demonstrated a willingness from the UK Supreme Court to consider an abundant understanding of corporate liability. Now that we are approaching the end of the year, we also have a new opportunity to reform our law, and by that, it represents another way to fight climate change. The absence of rapid government action to regulate corporate emissions will certainly bring more litigation against companies. As Joan Setzer put it, the principles necessitating climate action may be better incorporated into the law through legislation, and private law desperately needs it. Developments in climate science, particularly in respects of attribution and causation, will contribute to increase the significance of private law claims. I thank you so much for your kind attention and hope we can meet again.